judge in Fulton County, Georgia, today dismissed 6 charges in the state's election subversion case. The judge ruled that charges related to soliciting public officials to break the law lacked the required detail. The main racketeering indictment, however, remains intact. Andrew Weissmann and Melissa Murray join us now. They co-authored a new book, The Trump Indictments, the Historic Charging Documents with Commentary. Melissa, let me start with you. What is the import of today's ruling about the Georgia racketeering case?
Sure, Major. This is obviously a setback for the prosecution, but it's not necessarily a devastating one. The judge essentially said that while the prosecution pled the essential elements of the crime, they didn't fill in the necessary details. So it could be the case that the prosecution could go back to the grand jury, provide that necessary detail, and the grand jury could issue a superseding indictment here. It does leave, as you say, the RICO charges, the racketeering charges intact. And that really was the bulk of this sprawling prosecution. As we note in our book, this is an indictment that has a lot of color, a lot of detail. So we actually thought it was quite surprising that Judge McAfee thought that there wasn't the necessary detail here, because we thought this was an indictment that was long on details.
So, Andrew, if I hear Melissa correctly, this should not be precisely a celebratory moment for the Trump legal team.
That's right. They might spin it that way. And of course, no prosecutor ever likes to have any charges dismissed before getting to trial. But in terms of substance, they still have a lot of options. They could just decide, you know what, we don't really need those counts. And also, the judge actually invited them to go back to the grand jury and what's called supersede. That is to add sort of the necessary detail to those charges. Again, I don't think that there was really lacking that much detail, but it would be the kind of thing that would be relatively easy to cure. It is also important to note that the judge then, by not dismissing the rest of it, is saying those charges are good to go. So, if the defense is thinking that they're somehow going to be able to knock those out, the judge isn't saying that.
Melissa, I want to ask you, if there's a way to place a hierarchy of the cases facing former President Trump in terms of import, evidence, facts, and law, how would you establish or order that hierarchy?
Well, in our book, we really tried to sort of figure out what this hierarchy would be. But I think in the end, what we were left with is that they're all actually quite significant. I mean, I think everyone is focused on the January 6th election interference case that was filed in the District of Columbia. That's Jack Smith's case. That's obviously really important. It's obviously intertwined with Fani Willis's Fulton County case, which also speaks to the question of election interference and a broad, widespread conspiracy to subvert the results of a validly conducted election. But the Mar-a-Lago documents trial is also really important because of the sensitive classified information at stake. And then, of course, Alvin Bragg's Manhattan DA case concerning the hush money payments is also really important because it sort of sets up an earlier form of election interference, the idea of sequestering certain information from the voting public in order to enhance one's ability to win an election. So I think they're all quite significant. We had a hard time ordering them.
Andrew, in the court of public opinion, it is perceived that the Alvin Bragg case in Manhattan is a bit of a leap, is a novel application of prosecutorial discretion. How do you come down on that?
Well, we actually addressed that in detail in the book that Melissa and I wrote, because that's actually wrong. So first, the misdemeanor charges of just filing false business records, that's the bread and butter of what the Manhattan District Attorney's Office does. That's a standard charge, so there's nothing unusual about it. The only part that's unusual is when you charge it as a felony, and there are numerous ways in which that can be justified. The court actually ruled on pretrial motions brought by Donald Trump saying that those shouldn't be allowed, and the judge disagreed. 3 of the 4 theories that we sort of articulate in the book are ones that the judge said are going to go to the jury. And obviously, it still remains for Donald Trump to be tried. He's entitled to the presumption of innocence. The government obviously has to prove its case beyond a reasonable doubt as to each element. But there's nothing novel about the theory that is being used in this case, according to the trial judge in this case.
Melissa, you raised the January 6th case, and something in your book really caught my eye, and this goes to the issue of, was the Justice Department and its attorneys and investigators sufficiently aggressive on a January 6th type of case history will render its own judgment about that. But Cassidy Hutchinson's testimony, you write, came as a surprise to the Department of Justice. What does that tell you?
So again, as you say, it was a concerted choice to go with the rank and file members of that January 6th effort to overturn the election at the Capitol, to prosecute those lower level offenders before going for those at the top. The court of public opinion is going to play out on that decision, I think, for at least the next 10 years or so. What we thought was so surprising about Cassidy Hutchinson's testimony and what we noted in the book was that we were surprised that it left the Department of Justice sort of on the back foot. Like they weren't anticipating it. And again, you know, the real heroes here really are the January 6th congressional subcommittee that decided to hold these public hearings, solicited this information, and again, made it public, forcing the department's hand in many ways.
Andrew, I'd like you in our last minute to address a kind of meta issue. For the former president, he's counting on two things: the shock of these indictments giving him a political lift, and that's clearly happened in some instances, and the delaying tactics that preserve that political lift up until the election. Is there any way the judicial system can counteract either one?
Well, yes, it can by actually having a trial. You know, the way that we decide disputed issues in this country like this is to have a trial where facts and law matter. What's surprising here is you have the prosecutors saying we are welcoming this day in court. We want to give this day in court to the defendant. We are welcoming that we have to do this and win by proof beyond a reasonable doubt, the highest standard that we have in the law. And you have a defendant saying, I don't want to do that. I do not want my day in court. I want to do it after not just the general election, but essentially never. And that is an unusual thing, whereas you said this is one where I think Donald Trump would like this to play out with sort of spin and adjectives and adverbs, but not actually being in a forum where facts and law matter.
Andrew Weissmann and Melissa Murray, thank you very much for your time. We're all smarter for it.